Please be seated. Court is now in session. Call our next case is Pugh versus Boyd and Sons at AIG Claim Services, Inc. Fellas ready to proceed?
May it please the court, my name is Paul Anderson. I'm here today for my co-counsel Bill McCabe, who unfortunately suffered a ruptured appendix and could not be here today as he recovers. With leave of the court, I'd like to reserve 2 minutes for rebuttal. Section 440.105.4b1 makes it unlawful to make any false, fraudulent, or misleading statement for the purpose of obtaining any benefit or payment under Chapter 440. In conjunction with that section, 440.094a operates to bar benefits to a claimant who has committed a violation of 440.105 for the purpose of securing benefits under Chapter 440. In this case, while the judge of compensation claims questioned the appellant's veracity on a number of points, he ruled that there was a violation of 440.105 solely on what he concluded were misstatements on medical history made to Dr. Shields regarding the claimant's medical history between a 1972 work accident and the 2005 work accident we're here on today. And the simple issue before this court is there competent substantial evidence to support the judge's finding that this gentleman, the appellant, Mr. Pugh, made this purported misleading statement for the purposes of obtaining benefits under Chapter 440.
Were the statements that the judge pointed out, were they incorrect or not an accurate reflection of the facts?
I think there was an effort, and there was obviously conflict over whether the question was asked, how the question was perceived by the claimant, and how it was answered. But I think what's important, Your Honor, is, as Mr. McCabe pointed out in his statement of facts on page 14 and in argument within the initial brief on page 40, that the appellant, Mr. Pugh, was receiving workers' compensation benefits under Indiana law at the time that he made these purported statements. Mr. Pugh was not receiving and he was not seeking workers' compensation benefits under Chapter 440. He did not even file a claim for benefits under Chapter 440 until July of the following year, some 6 months later. Thus, even if the statement is accepted as being misleading or fraudulent or false, it cannot reasonably be said that it was made knowingly with a conscious effort to secure benefits under Chapter 440.
Are you saying as a matter of law a false statement made in a proceeding in Indiana or some other state would preclude it from being an operative misrepresentation under our statute?
Well, I think what I'm saying, Your Honor, is that what the express terms of the statute provide is that a knowing misstatement needs to have been made for the purpose of securing a benefit under Chapter 440, and that those facts don't exist here because this gentleman did not have a claim, was not receiving benefits under Chapter 440 at the time of this misstatement. He was receiving benefits, but under Indiana law, and in fact under that state's workers' compensation system, had been sent to Dr. Shields. Even if the appellant made the purported misstatement and it was false or misleading.
Well, you call it misstatement, Mr. Anderson. Can I clarify? I mean, it seems like there's several places in the JCC's order where he found, I mean, I do not find this as an excuse as to why he did not truthfully and completely answer. I find, he testified he can't recall whether I did or didn't. This was at the hearing in front of the JCC. I find such statement is clearly disingenuous and misleading. He also claimed he did not know that darvastat was a narcotic. I find after considering the totality of the claim his testimony and trial, the claim exhibits a propensity to misstate or minimize the truth in an effort to advance his claim. I mean, there was just numerous references throughout the order of different instances where the JCC determined that your client was not being, well, at least wasn't being forthright.
I acknowledge that, Your Honor. He clearly did say that, but in reality, if you look at his actual ruling, the only thing he found to be the basis for finding a violation of 44105 was the medical history purportedly provided to Dr. Shields. That is the basis on which, at the end of his order, he rules that there's been a violation of 44105. I think even if there's been a violation of 44105, the question then becomes, is it necessary for that representation to be a material misrepresentation? And as Mr. McKay pointed out in his brief, this Court's rulings on that issue seem to be in conflict.
On materiality?
Yes, Your Honor.
Wasn't that because, I mean, the different provisions, I mean, 105 B1 doesn't require materiality, but B2 does, correct?
That's correct, Your Honor. Nonetheless, in the cases that have been decided in this Court, for instance, in Village of North Palm Beach versus McHale, on which I believe you had a concurring opinion, it states that a false or misleading statement need not be material. It's only necessary that it be made for the purpose of obtaining benefits under Chapter 440. Yet in Chapman versus Nations Bank, CDL versus Korea, which preceded the Village case, and in the subsequent decision in Citrus Pest Control versus Brown, which I believe Judge Lewis authored and Judge Browning concurred, the remands in those three cases were with instructions to the JCC to determine if there had been a misstatement that was material to the claim. So there is some confusion on that. Both parties agreed in their briefs that in most other areas of law, materiality is important, whether it's forfeiture of insurance benefits, perjury, dismissal of a civil claim for fraud, Martin versus Carpenter in prior comp cases. Even in subsection 2, as you point out, Judge Hawks, a misstatement must be material to a claim to warrant a finding of fraud and the imposition of whatever sanctions are associated with that fraud. And in this case, I would submit that the misstatement, even if made, was not material to this case, because Dr. Shields, even when presented with the additional medical history, said, well, you know, my opinion still stands. This man's herniated disc is related to this 2005 accident. So in conclusion, we submit that even if the purported history given to Dr. Shields was false or misleading as the judge determined, it doesn't violate 44105 because it was not a statement made for the purpose of securing benefits under Chapter 440. This man was receiving benefits, but under Indiana law, he had no claim, was not seeking payment of benefits under Florida law. And the statement was ultimately not material to the claim, in that Dr. Shields, even when presented this sporadic history, and as your honors can see from the evidence, it was 1 year he'd see a chiropractor one time, maybe he'd go 2 years and he'd see the chiropractor 2 or 3 times. We also know that some of his back complaints, by the testimony, may more likely have been related to prostate problems and the colon cancer that he suffered. So we would submit that there is no competent substantial evidence to support the judge of compensation claims finding based on the specific language and requirements of the statute, and that the JCC's conclusion then that Mr. Pugh is barred from benefits under 44009 must be reversed, and the surgery denied must be awarded.
Let me see if I understand your argument. So one of your arguments is that because he was receiving Indiana compensation at the time, that he provided the information that Judge Lazare found at least misleading, that could never be, even if you attempt to use that same information in a Florida proceeding, it would never be a barred recovery.
I would never say never to a court, because that would.
But does his use of that information, isn't that really in pursuit of a Florida claim when you go and use it to pursue Florida benefits, even at a subsequent time?
No, because the key analysis for purposes of this statute is when the statement is made, was it knowingly false, fraudulent, or misleading, and made for the purposes of securing benefits under Chapter 440. That's the express language. Now, in this case, that could not have occurred because this man was not receiving, was not seeking, was not pursuing any type of benefit under Florida law.
Well, I mean, the statute, reading the statute, number one, which, to knowingly make, but number two is to present or cause to be presented. So that would be a statement that you made in the past, wouldn't it, that was incorrect, and now you're presenting that statement at this point in time by, in essence, relying on it, or would that not be presentment?
Well, I think what's happening here is that the defense in the case tried to use that past statement and pull it into the Florida claim, even though it was made at a time where there was no Florida claim.
And so even at the hearing, when he is explaining to the judge why he made misleading statements, those misleading statements don't count.
Well, if he made misleading statements that the judge found to be a violation of 44105, yes, they would count. But in this case, the only misstatement that the judge considered sufficient to violate 44105 was the history provided Dr. Shields.
And does he have to put that in that part of the order? In other words, if the judge says in his order, I mean, we have a lot of administrative law cases that say that because the administrative law judge labels something a fact or labels something a conclusion of law, isn't going to determine if it's a fact or a conclusion of law. What reality is going to determine. So here, when the judge says that when he answered this question at trial, that was misleading, then wouldn't that be an error of law then for the judge not to suspend benefits pursuant to 105 if, in fact, the judge concluded that he made a misleading statement?
Well, Your Honor, I haven't thought of it along those terms, but it hasn't been asserted as an error of law, and I know this Court is adamant about not retrying cases at the appellate level. So what we're looking at here is solely what the judge ruled on and whether that is supported by competent substantial evidence.
And your time is up. We'll add 1 minute to opposing counsel's time if she so desires as a result of the overrun.
Thank you, Judge. Good morning. May it please the Court. My name is Mary Wakeman. I represent the appellees in this case, Boyd & Sons and AIG Claims Services, who are the employer and carrier in Mr. Pugh's workers' compensation case. I'd like to point out to the Court that the argument Mr. Anderson just made was never raised below, nor was it raised in his
I was going to ask him that because I didn't see it in the briefs. But.
Yeah, first time I've heard it. The argument raised below was that there would be no reason for the claimant to lie to Dr. Shields because he was already receiving Indiana workers' compensation benefits. Therefore, he would have no reason to, misstate his medical history because he was already getting benefits. But the claim that the claimant filed in Florida was seeking surgery as authorized by Dr. Shields. So even if you accept the argument that it didn't meet the statutory definition under 440, he brought the claim to Florida, said, I want the surgery that this doctor recommended, and that was the doctor that he made the misstatements to.
Or wouldn't that misstatement be, so to speak, republished in Florida?
Sure.
In that context, as you know, any case law that says that that's, once you invoke it, even though it was given in a foreign jurisdiction, that it would not be actionable under our statute?
Correct. I mean, he was presenting it for the purpose of trying to get the surgery authorized, which was his claim here in Florida. As Judge Hawks pointed out, the JCC identified several areas where he felt that the claimant was misstating his medical history and other things, and ultimately led the judge to the conclusion that he had violated Section 440-105. In the JCC's order at the beginning, he says, I've attempted to distill all of the facts. The fact that I may not specifically mention a particular piece of evidence doesn't mean that I've overlooked it or not relied upon it. And throughout the order, as Judge Hawks pointed out, the JCC said definitely with Dr. Shields, he was not forthright about his prior medical history. Claimant answered at the hearing that he didn't recall whether the previous 3 doctors had treated him for prior back pain, even though there was a legion of medical records showing back pain treatment dating all the way back to 1972, and the hearing didn't occur until 2007. The JCC said he found the claimant clearly disingenuous and misleading. The claimant also misrepresented the extent of his prior back treatment during his deposition, which was taken after he filed a claim in Florida, where he testified that he only experienced occasional back pain every now and then, but didn't have any back problems, quote, unquote. And ultimately, the JCC found, after weighing all of the evidence, observing the claimant's demeanor, that the claimant exhibited a propensity to misstate or minimize the truth to advance his workers' compensation claim. And there is competent, substantial evidence in the record to support that finding. Regarding the issue about whether the misstatements were material or not, this court has said in the McHale case that materiality is not necessary. It's just there must be a finding that a false, fraudulent, or misleading statement be made for the purpose of obtaining workers' compensation benefits, and the judge here made that finding. Nonetheless, these statements were material to the claimant's claim. In Village Apartments versus Hernandez, this court has said statements about prior medical history are material. Dr. Shields testified that if there was a history of this chronic back pain, that would be relevant to the issue of causation. It's also relevant to the issue of apportionment under our statute if some of the injury can be apportioned to an earlier condition. And the JCC pointed out that Dr. Shields had said obtaining an accurate medical history is important so that the doctor can, make a plan for treatment and render opinions on causation. The employer carrier should not have to engage in its own discovery to locate the truth about the claimant's condition. And this court has pointed that out over and over. The litigant, the claimant, should be forthcoming and should not be trying to hide facts that are pertinent or relevant to the claim. Regarding the Chapman and CDL cases, I do not believe there is any conflict between those opinions and the other opinions of this court, because in those two cases, the judges had actually found that there were misstatements, but they went ahead and awarded benefits anyway. And in those two cases, this court said, we're going to remand the cases back down because the JCC has to make a finding about materiality to the claim. And as Judge Hawks pointed out, materiality does apply to certain provisions of 44105, but not all. So again, because competent substantial evidence supports the JCC's findings that the surgery should not be authorized based on the misstatements, we would ask the court to affirm the JCC's order in all respects. And I don't think I need my extra minute. Thank you.
Okay. You gave us 5 back. Thank you. Well, you didn't save any time for rebuttal, but... Well, we'll give you, I'll tell you what we'll do. We'll give you 45 seconds.
Well, with all due respect, the argument's very clear and concise. I don't think I need to rebut. I would answer any question that the court might pose, but beyond that, I don't need any time. Thank you, though.
Okay. Thank you. Appreciate it.